Ma'am, I need you to step over here right now.
I'm an attorney. I just finished a court hearing. What's this about?
You're being detained for immigration violations.
Immigration violations? I was born in Detroit.
Attorney Rachel Okonkwo had spent the last 8 years defending immigrants in federal court. She'd argued deportation cases, asylum claims, and constitutional challenges to immigration enforcement. She knew the law better than most federal agents. She understood her rights. And on that Tuesday afternoon in March, 2 ICE agents decided she looked suspicious leaving a federal courthouse in downtown Chicago. They demanded her papers, questioned her citizenship, and detained her for 6 hours based on nothing except her accent and her appearance. Rachel was a natural-born American citizen. She had a birth certificate from Henry Ford Hospital. She'd lived in the United States her entire life. But to Special Agent Kyle Morrison and his partner, those facts didn't matter. They saw a black woman with an African name speaking with a slight Nigerian accent inherited from her parents, and they made assumptions that would cost the federal government $16.8 million. Federal courthouses are supposed to be neutral ground, places where law matters more than bias, where credentials carry weight, where attorneys can practice without being criminalized for existing. Rachel Okonkwo had walked out of the Dirksen Federal Building after a routine asylum hearing. She was carrying her briefcase, wearing a professional suit, holding case files clearly marked with court stamps. She looked exactly like what she was, a lawyer finishing her workday. But Agent Morrison saw something different. He saw someone who, in his mind, didn't belong in that building, didn't belong in that role, couldn't possibly be a legitimate American attorney. Morrison had been with Immigration and Customs Enforcement for 12 years. He'd worked deportation cases, enforcement operations, and compliance investigations. His record showed a pattern: 43 complaints over 12 years. 37 of them involved questioning naturalized citizens or legal residents about their immigration status based on appearance or accent. Each complaint ended the same way: mandatory retraining that Morrison attended but never applied, cultural sensitivity workshops that didn't change his approach, supervisory counseling that produced no behavioral modification. The system had documented Morrison's pattern for over a decade, but documentation without consequences just becomes a paper trail, leading to the inevitable lawsuit. Rachel was 34 years old. She'd been born at Henry Ford Hospital in Detroit to Nigerian immigrant parents who'd come to America legally in the 1980s. Her father was a professor of engineering at Wayne State University. Her mother worked as a nurse at Detroit Medical Center. They'd raised Rachel in a middle-class neighborhood, sent her to good schools, and watched her excel academically. She'd graduated from the University of Michigan, then Northwestern Law School. She'd clerked for a federal judge, worked at a nonprofit immigration legal services organization, and eventually opened her own practice specializing in deportation defense. She'd argued cases before immigration judges, federal district courts, and the Seventh Circuit Court of Appeals. She'd won asylum for refugees, stopped deportations of longtime residents, and challenged unconstitutional enforcement practices. Her clients trusted her. Judges respected her. Other attorneys consulted her on complex immigration issues. That Tuesday, Rachel had spent the morning in immigration court, representing a Guatemalan woman facing deportation. The hearing had gone well. The judge had granted a continuance to gather additional evidence. Rachel had packed her files, said goodbye to her client, and left the building through the main entrance on South Dearborn Street. It was 2:15 in the afternoon. The sun was bright. The sidewalk was crowded with lawyers, clerks, and visitors moving between the courthouse and nearby office buildings. Rachel was thinking about her next appointment, mentally reviewing the arguments she'd need to prepare for another case. She was walking toward the CTA station, planning to take the Red Line back to her office. Normal afternoon, routine day, no indication anything was wrong. Then she heard the voice behind her. "Ma'am, federal agents, stop right there." Rachel turned around and saw 2 men in dark suits with badges hanging from their belts. Her professional instincts kicked in immediately. She recognized ICE credentials. She'd dealt with immigration enforcement her entire career, but she'd always been on the other side of these interactions, representing clients, not being targeted herself. "Excuse me, is there a problem? We need to see your identification and immigration documents." Rachel felt confusion before anger. "Immigration documents? I'm an attorney. I just left a court hearing." Agent Morrison stepped closer. His partner, Agent Teresa Valdez, positioned herself to Rachel's left, creating a formation that felt less like a conversation and more like containment. "Ma'am, we have reason to believe you may be in violation of immigration law. We need to verify your status." The absurdity of the situation was overwhelming. Rachel was standing on a public sidewalk outside a federal courthouse where she'd just represented a client. She was wearing a suit. She was carrying a briefcase with her law firm's name embossed on the side. Her bar card was in her wallet. Her driver's license showed her Detroit address. But Morrison had decided she looked suspicious, and nothing about her appearance suggested otherwise to him. "What reason? What specific reason do you have to believe I'm in violation of any law?" "Your accent, your appearance, the fact that you were in the courthouse." Rachel's legal mind processed this instantly. Those weren't legal reasons. Those were pretexts masking bias. "My accent? I was born in Michigan. My appearance? I'm a natural-born citizen. And being in a courthouse isn't suspicious. For an attorney who practices there, we're going to need to verify that." "Where were you born?" "Detroit. Henry Ford Hospital." "When?" "March 14th, 1989. "What were you doing in the courthouse?" "Representing a client in immigration court." "I'm an attorney. I practice immigration law." Morrison's expression didn't change. He'd heard explanations before. In his experience, people who claimed to be citizens were often lying, trying to avoid detention. The accent bothered him. The confidence bothered him. The fact that she was questioning his authority bothered him most of all. "Ma'am, I'm going to need you to come with us to verify your information." Rachel's anger finally surfaced. "Verify my information? I've told you I'm a citizen. I've told you I'm an attorney. I just walked out of a federal courthouse where I was working. What exactly do you think I've done wrong?" Agent Valdez spoke for the first time. "Ma'am, if you're really a citizen, this will be resolved quickly. But we need to follow procedures." Rachel knew procedures. She'd studied immigration enforcement protocols. She'd challenged unlawful detentions in court, and she knew exactly what was happening right now. This was racial profiling dressed up as immigration enforcement. "I'm not going anywhere without a warrant or probable cause, and you have neither." Morrison's jaw tightened. "Ma'am, refusing to cooperate gives us reasonable suspicion." "That's not how the law works, Agent Morrison. Reasonable suspicion requires articulable facts suggesting criminal activity. Speaking with an accent isn't a crime. Being Latina isn't a crime. Walking out of a courthouse where I work isn't a crime. You have zero legal basis for this stop." The sidewalk was getting crowded. Afternoon foot traffic increased as people left work early, heading home before rush hour peaked. Some slowed down, watching the confrontation. A woman pulled out her phone, recording. Rachel noticed and felt a small surge of relief. Documentation mattered. Evidence mattered. This wasn't happening in shadows. Morrison noticed the phone, too. His tone shifted slightly, less aggressive but more insistent. "Ma'am, we can do this here or we can do this at the office. Your choice. But we're verifying your status one way or another." Rachel pulled out her wallet. Inside was her Michigan driver's license, her State Bar of Michigan card, 2 credit cards in her name, and her law firm ID badge. She held up the bar card. "This is my bar card. I'm a licensed attorney in Michigan. My license number is P74829. You can verify that with the State Bar right now." Morrison glanced at it but didn't reach for it. "Anyone can print a fake ID. That's not a fake ID. It has security features, a hologram, my photograph. It's issued by the State Bar of Michigan after passing character and fitness review, which includes immigration status verification. If you doubt its authenticity, call the bar. The number's public." Valdez pulled out her phone and stepped away, presumably to make that call. Morrison stood his ground, blocking Rachel's path. "Ma'am, while we're verifying, I need you to stay here." Rachel's legal training collided with her rising fury. She knew her rights. She knew immigration enforcement powers. She knew the limits of ICE authority. And she knew Morrison had exceeded those limits the moment he stopped her based solely on appearance. "Agent Morrison, what's your badge number? Why do you need that? Because I'm filing a complaint. You've detained me without reasonable suspicion. You've demanded documentation without legal authority. And you've done it based on racial profiling. I want your badge number and your supervisor's name." Morrison's face flushed. "You're not detained. You're free to go after we verify your status. Those are contradictory statements. Either I'm free to go or I'm detained. Which is it? You're being uncooperative. That's not a legal standard. Uncooperative isn't a crime. And even if it were, it wouldn't give you authority to demand my papers on a public sidewalk." Valdez returned, her expression uncomfortable. "The bar confirms Rachel Ortiz is a licensed attorney in good standing. License issued 2016, no disciplinary actions." Morrison's certainty wavered but didn't break. "That confirms she's an attorney. Doesn't confirm immigration status." Rachel stared at him in disbelief. "You think the State Bar of Michigan licenses undocumented immigrants to practice law? You think I passed a federal background check, a character and fitness review, and somehow slipped through without immigration status verification?" The absurdity was complete. Morrison had stopped Rachel based on bias, found evidence contradicting his assumption, and doubled down anyway. His mental narrative couldn't accommodate the possibility that a Latina woman with an accent could be both a citizen and an attorney. Those facts didn't compute in his worldview. A man in a suit stopped near them. He'd been watching from across the street. "Excuse me, is there a problem here?" Morrison turned. "Sir, this is federal business. Please move along." The man pulled out his own credentials. "I'm Judge William Patterson, Eastern District of Michigan. I was in the courthouse today for a hearing." He looked at Rachel. "Ms. Ortiz, were you representing a client in my courtroom this afternoon?" Rachel felt relief wash over her. "Yes, Your Honor. The Ramirez matter." Judge Patterson turned to Morrison with barely concealed disgust. "Agent, this woman is a licensed attorney who appeared before me in federal court 2 hours ago. She's a United States citizen, and what you're doing right now is unlawful detention based on racial profiling." Morrison's face went from flushed to pale. "Your Honor, we received information." "What information? That she's Latina? That she has an accent? Those aren't crimes." Judge Patterson's voice carried authority that came from 30 years on the bench. "Agent, I suggest you end this encounter immediately. Otherwise, Ms. Ortiz will have grounds for a federal lawsuit that your agency will lose." Morrison stepped back. "Ma'am, you're free to go." Rachel didn't move. "That's it? You detain me, demand my papers, ignore my credentials, and now I'm just free to go? I want your supervisor's name. I want the incident report number. And I want everything documented because I'm filing a formal complaint and pursuing legal action." Valdez provided the information quietly, her discomfort obvious. She hadn't initiated the stop. She'd followed Morrison's lead, but she'd participated, and that made her complicit. Judge Patterson stayed until Rachel had all the details she needed, then offered to walk her to the train station. As they walked, he spoke quietly. "Ms. Ortiz, I've seen this pattern before. ICE targeting people based on appearance near courthouses. It's intimidation, it's profiling, and it's illegal. You should absolutely file that complaint." Rachel nodded, her hands still shaking slightly from adrenaline. "Your Honor, I represent clients who face this every day. People who don't have bar cards or judges vouching for them. This isn't about me. It's about a system that lets agents like Morrison operate with impunity." Judge Patterson was one of 12 federal judges who'd been documenting similar incidents for months. Courthouse steps, parking lots, transit stations near federal buildings, ICE agents targeting individuals based on appearance. accent, skin color. The pattern was undeniable. Within 48 hours, Patterson had contacted the chief judge of the Eastern District. Within 72 hours, Rachel had contacted the ACLU. Within a week, her story was national news. Federal lawsuit filed within 30 days. Rachel Ortiz versus Department of Homeland Security, naming Agent Morrison individually. The claims were straightforward. Fourth Amendment violation for unlawful seizure without reasonable suspicion, equal. Protection violation for racial profiling. First Amendment violation for targeting her near a courthouse where she'd exercised her right to legal representation. The complaint was 23 pages, meticulously cited, devastating in its detail. Morrison's employment file told the story his supervisors should have addressed years earlier. 14 complaints over 6 years. All 14 involving stops of Latino individuals. 7 involved demands for immigration papers from U.S. citizens. 3 involved attorneys. Every single complaint followed the same script. Latino appearance plus accent equals assumed illegality. The pattern wasn't subtle. It was Morrison's standard operating procedure. Internal emails made it worse. Morrison had sent messages to colleagues joking about courthouse arrests. He'd referred to immigration attorneys as criminal enablers. He'd shared memes mocking people with accents. His supervisors had the emails. They'd done nothing. One supervisor had responded to Morrison's joke about arresting someone outside court with a laughing emoji. That email became Exhibit C in Rachel's lawsuit. Discovery revealed something even more troubling. ICE had implemented an unofficial policy of increased enforcement near courthouses, where immigration cases were heard. The stated goal was deterring illegal immigration. The actual effect was intimidating citizens and legal residents from accessing courts. Defense attorneys reported clients missing hearings because they feared arrest walking into federal buildings. Witnesses refused to testify. The justice system was being undermined by the very agency claiming to enforce the law. Rachel's case became the vehicle for challenging that entire practice. Her attorneys deposed Morrison for 6 hours. The transcript was brutal. Question after question exposing his assumptions, his bias, his complete inability to articulate any legitimate law enforcement reason for stopping her beyond her appearance and accent. Asked what specific suspicious behavior she'd exhibited, Morrison couldn't name any. Asked why he'd ignored her bar card, he claimed anyone could print fake credentials, which was demonstrably false given the security features on attorney identification. The most damaging moment came when Rachel's attorney asked Morrison a simple question. Agent Morrison, in your 6 years with ICE, how many white individuals with European accents have you stopped and questioned about immigration status? Morrison paused for 18 seconds. The court reporter noted the silence. Then he answered, I don't recall any specific instances. Follow-up question. Can you estimate how many? Morrison shifted in his seat. Probably none. Why not? Because European immigrants typically enter legally. And you determined that how? By looking at them? Morrison's attorney objected, but the damage was done. The deposition transcript showed exactly what Rachel's lawsuit alleged. Morrison profiled based on race and ethnicity, period. Meanwhile, the broader implications were spreading. The American Bar Association issued a statement condemning ICE courthouse enforcement. The National Association of Criminal Defense Lawyers filed an amicus brief supporting Rachel's case. 12 federal judges signed a letter to the Attorney General demanding policy changes. Immigration advocacy groups rallied around Rachel as a symbol of resistance against racial profiling in the justice system. Morrison was placed on administrative leave 8 weeks after the incident. The decision came after Judge Patterson and 4 other federal judges filed formal complaints with DHS Inspector General. The judges provided detailed accounts of similar incidents they'd witnessed. One judge described watching ICE agents detain a court interpreter, a U.S. citizen who'd worked in federal court for 15 years, simply because she spoke Spanish. Another judge reported agents questioning jurors of Latino descent as they left the courthouse. The pattern was systemic. Rachel's case went to mediation after 18 months. Federal cases move slowly, but the evidence was so one-sided that DHS attorneys recommended settlement. The government didn't want Morrison's deposition played in open court. They didn't want internal emails about Courthouse targeting becoming public record. They especially didn't want 12 federal judges testifying about a pattern of constitutional violations. Settlement reached. $1.9 million paid to Rachel Ortiz. Agent Morrison terminated. Name entered into federal law enforcement databases preventing rehire. DHS required to implement new training on racial profiling and Fourth Amendment requirements. ICE forbidden from conducting enforcement actions within 200 feet of courthouses absent specific criminal warrants. The policy change was the victory Rachel cared about most. The money was secondary to protecting future clients from experiencing what she'd endured. Morrison released a brief statement through his attorney. "I made errors in judgment and allowed personal biases to affect my professional conduct." That wasn't an apology. That was damage control from someone who'd lost everything and still couldn't admit the fundamental wrongness of his actions. Rachel continued practicing immigration law. The publicity from her case brought new clients, people who'd been profiled, detained, questioned without cause. She specialized in civil rights violations now, representing citizens and legal residents targeted by agents who assumed documentation status based on appearance. Her bar card story became legend in Michigan legal circles. Young attorneys asked her advice about asserting rights when confronted by law enforcement. She told them the same thing every time. Know the law better than they do, document everything, and never accept being treated as less than because of how you look or sound. What happened on those courthouse steps wasn't rare. Rachel's lawsuit revealed hundreds of similar incidents documented by advocacy groups, attorneys, and judges across the country. People being stopped, questioned, detained based on nothing but skin color, language, or last name. But most didn't have federal credentials. Most didn't have judges watching. Most didn't have the resources to fight back. Rachel's settlement changed that calculus. 1.9 million sent a message. Constitutional violations carried real consequences when victims had the knowledge and determination to pursue them. The internal affairs investigation into Morrison expanded beyond Rachel's case. DHS reviewed his entire career. Every stop, every detention, every enforcement action, over 12 years. They found patterns that should have ended his career years earlier. A naturalized citizen from India detained for 40 minutes outside a Boston courthouse. Morrison questioned her repeatedly about her immigration status, despite seeing her U.S. passport. She filed a complaint. Internal Affairs dismissed it, found Morrison acted within policy. A Mexican-American attorney stopped while entering a federal building in Detroit. Morrison demanded documentation proving citizenship. The attorney showed his Michigan driver's license and bar card. Morrison ran his information anyway, made him wait 30 minutes. Complaint filed, resolved with verbal counseling for Morrison. A Puerto Rican family leaving immigration court in Grand Rapids. Morrison followed them to their car, questioned whether their documents were authentic. Puerto Ricans are U.S. citizens by birth. Morrison either didn't know or didn't care. Complaint filed, closed with diversity awareness training requirement. 17 complaints over 12 years, all involving Latino individuals or people Morrison perceived as foreign. Every complaint dismissed or resolved with training that changed nothing. The pattern was documented, preserved in his personnel file, ignored by supervisors, who valued enforcement numbers over constitutional compliance. Rachel's attorney subpoenaed Morrison's complete file during discovery. Those 17 complaints became exhibits in her lawsuit. Each one showed the exact same bias. Each one represented a victim who'd been profiled and received no justice. The deposition transcripts were devastating, but the complaint history sealed Morrison's fate. You can't claim one incident was an isolated mistake when 17 previous incidents followed identical patterns. DHS couldn't defend that. They couldn't explain why Morrison remained in courthouse enforcement after Complaint 5, after Complaint 10, After complaint 15. They couldn't justify a system that treated each violation separately instead of recognizing the obvious pattern they formed together. Judge Patterson testified during the administrative proceedings that led to Morrison's termination. His testimony was brief but powerful. In 23 years on the federal bench, I've seen many ICE agents conduct themselves professionally and respectfully. Agent Morrison was not one of them. I watched him target individuals based on appearance. I watched him question attorneys, defendants, witnesses, anyone who looked Latino or spoke Spanish. I watched him create an atmosphere where people feared coming to court, feared exercising their constitutional rights, feared being detained simply for seeking justice. That's not law enforcement. That's discrimination with a badge. The 12 federal judges who signed the letter to the Attorney General didn't stop there. They formed a coalition pushing for systemic reform. They documented hundreds of incidents across multiple states. They provided data showing courthouse enforcement disproportionately targeted people of color. They demonstrated how ICE presence in courthouses undermined judicial independence and constitutional protections. Their advocacy led to policy changes beyond just the 200-foot rule. DHS implemented new guidelines requiring supervisory approval for courthouse operations. Agents needed documented intelligence about specific criminal targets, not general enforcement sweeps. Body cameras became mandatory for courthouse assignments. Complaints triggered automatic review by headquarters rather than local supervisors who might protect problematic agents. But policy changes on paper don't automatically translate to changes in practice. Implementation takes time, enforcement takes will, and accountability requires consequences when policies are violated. Rachel knew that. She'd seen the gap between written rules and real-world behavior throughout her career, so she didn't stop with her own settlement. She became an advocate for others. Pro bono representation for victims of ICE profiling. Testimony before congressional committees about courthouse enforcement. Training sessions for attorneys about documenting civil rights violations. She turned her experience into a platform for systemic change, using her case as proof that fighting back worked. Morrison disappeared from public view after his termination. His name appeared in legal databases as an example of what not to do. His deposition became required reading in some law school civil rights courses. His career became a cautionary tale about unchecked bias and institutional failure to address obvious patterns. Whether he ever genuinely understood what he'd done wrong remained unclear. His statement suggested he viewed it as errors in judgment rather than fundamental character failures. That distinction mattered. Errors in judgment suggest mistakes that could happen to anyone. What Morrison did wasn't accidental. It was consistent, deliberate, and documented over 12 years. That's not judgment errors. That's who he was, revealed through how he treated people he had power over. Rachel's bar card, the one Morrison confiscated on those courthouse steps, sits framed in her office now. Not as a trophy, but as a reminder. A reminder that credentials don't protect you from bias. A reminder that knowing your rights matters only if you're willing to assert them. A reminder that one person standing up can expose patterns that harm hundreds. She tells clients who ask about the frame that it represents, the moment she stopped being just an attorney and became someone who understood exactly how systems of power operate when they're not being watched closely. Morrison saw a Latina and assumed illegal immigrant. He saw someone he could intimidate, detain, question without consequence. He didn't see an attorney who understood federal law better than he did. He didn't anticipate someone with the resources and determination to fight back. He certainly didn't expect federal judges to rally behind her. His mistake cost him everything because Rachel refused to accept that being questioned at a courthouse was just part of being Latina in America. The 200-foot rule exists now because 12 federal judges decided institutional dignity mattered more than staying quiet. ICE can't just post agents at courthouse entrances hoping someone looks deportable. They need warrants, specific targets, supervisory approval. The presence that used to feel like occupation now requires justification. That didn't happen through quiet diplomacy. It happened because Rachel documented everything, filed strategically, and forced a reckoning that exposed how routine Morrison's behavior had been. Other attorneys started coming forward after Rachel's settlement became public. A defense lawyer in Phoenix detained while representing a client. An immigration attorney in Houston questioned repeatedly despite showing credentials. A public defender in Miami, whose clients stopped showing up to court after ICE started camping outside. Each story followed Morrison's playbook. See someone brown, assume they're undocumented, create enough intimidation that people avoid the courthouse entirely. The pattern wasn't limited to one agent or one city. It was systemic, enabled by policies that prioritized enforcement over constitutional protections. Rachel's case became the template for challenging those practices. Her documentation methods, her strategic use of witnesses, her insistence on preserving every piece of evidence. Other attorneys studied her approach. Civil rights organizations incorporated her tactics into training materials. Law schools taught her case alongside landmark Supreme Court decisions about government overreach. She'd turned 12 minutes of harassment into a blueprint for accountability. Morrison's termination sent ripples through ICE that his supervisors hadn't anticipated. Agents who'd operated similarly suddenly faced scrutiny. Complaint files that had gathered dust got reopened. Body camera footage from courthouse operations underwent review. The spotlight Rachel created didn't just illuminate Morrison. It exposed an entire culture that had normalized profiling as effective enforcement. The settlement money Rachel received went further than personal compensation. She established a legal defense fund for immigrants detained at courthouses, not for immigration proceedings, but for civil rights violations during those detentions. The fund paid for attorneys who could challenge unlawful stops, document patterns, file complaints that actually got investigated. She used Morrison's money to build the infrastructure that would prevent future Morrisons from operating unchecked. Immigration courts noticed the difference within months. Attendance rates improved when people stopped fearing arrest simply for showing up. Attorneys reported clients felt safer seeking legal recourse. Judges observed fewer disruptions caused by enforcement actions in their buildings. The 200-foot rule created breathing room that allowed the justice system to function without doubling as an enforcement trap. But implementation remained inconsistent. Some ICE field offices embraced the new policies. Others found workarounds. Agents who couldn't wait inside courthouses started surveilling parking lots, following people from their cars. The letter of the policy got followed while the spirit got ignored. Rachel documented those evasions too, filed additional complaints, pushed for clarifications that closed loopholes. She'd learned that writing rules meant nothing without enforcement mechanisms and consequences for violations. Federal judges continued monitoring courthouse enforcement even after policy changes. They filed reports documenting compliance and violations. They testified when Congress held hearings about immigration enforcement. They used their institutional authority to demand accountability from agencies that typically operated beyond judicial oversight. Rachel had given them proof that their concerns weren't theoretical. Morrison's pattern demonstrated exactly what happened when enforcement went unchecked in judicial spaces. The broader immigration debate continued with all its complexity and political division. Rachel's case didn't resolve questions about border policy or deportation priorities, but it established something narrower and more fundamental. Courthouses aren't enforcement zones where constitutional protections disappear. Attorneys aren't suspects who need to prove their right to practice law, and badges don't grant unlimited authority to detain people based on assumptions about their appearance. Morrison made those assumptions for 12 years before encountering someone who wouldn't accept them. 12 years of stops that probably numbered in the hundreds. How many people did he question who weren't attorneys, who didn't know their rights, who couldn't afford to fight back? How many immigrants avoided court because they'd heard stories about ICE waiting at the doors? How many cases went unresolved because defendants chose deportation over the risk of arrest while seeking justice? Those questions don't have precise answers, but Morrison's personnel file suggested the scope. 12 years on courthouse assignment, dozens of documented stops, patterns supervisors acknowledged but didn't address until a federal lawsuit forced their hand. The people he profiled before Rachel didn't have her resources or platform. They absorbed the harassment as unavoidable, warned others, adjusted their behavior to avoid triggering his attention. Morrison relied on that silence. He didn't anticipate someone documenting everything and turning it into federal evidence. Rachel still practices law, still represents clients at the same courthouse where Morrison detained her. She sees the 200-foot markers painted on the ground now, the visible reminder that enforcement stops at the perimeter. She notices ICE agents occasionally, but they're no longer posted at entrances, no longer creating the intimidating presence that used to greet anyone who looked like they might not belong. The building feels different, not perfect, not free of all problems, but different in ways that matter to people who need to access justice without fearing arrest for their appearance. That change happened because one attorney refused to accept that being detained at a courthouse was normal, because she knew documentation mattered, because she understood that patterns continue until someone forces them into the light where they can't be ignored anymore. Morrison's career ended, but the system that enabled him for 12 years faced consequences too. Policies changed, oversight increased, and the message became clear. Constitutional rights don't stop at the courthouse steps, and people who know that are willing to fight for it. Morrison's mistake wasn't stopping one attorney. His mistake was believing the pattern could continue indefinitely without encountering someone who'd turn it into evidence. Rachel's settlement didn't just compensate her. It proved that documentation defeats assumptions, that rights matter when people defend them, and that systems protecting bias eventually face costs they can't absorb. The 200-foot rule exists because she refused to accept that courthouse harassment was simply part of being Latina in America.